So I think we're live now, Britt, yes?
Yes, ma'am.
Well, good afternoon and welcome. Thank you for taking time out of what we know are exceedingly busy schedules to be in this conversation with us, to both celebrate and contemplate the 30th anniversary of the Americans with Disabilities Act. My name is Allison Nichol. I am the Director of Legal Advocacy at the Epilepsy Foundation, and I will be your moderator for today. The first thing I'm going to do is start with instructions for captioning. I think that takes us to our next slide. So this is how you access the closed captioning for this event. As you'll see by looking at your screen, we have an ASL interpreter with us as well. To view the caption, find the closed captioning button on your toolbar. Click the up arrow to the right of the closed caption and then click show subtitle. Click the subtitle setting to change the caption size if that's necessary for you, and then click view full transcript to review all of the captions. So let me just give people a moment to do that, and we'll leave those instructions up for a second so folks can access the captions as needed. Okay, let's advance the slide. Okay, who are all these people? So this is a photograph I will describe in a minute, but first it's my absolute privilege to introduce our speakers today. If I were to give a fabulous dinner party to have conversation about the ADA, I would hope that each of these people would grace my table. So first, let me start, of course, with Tony Coelho. Tony is the former United States Congressman from California, as many of you already know, and he is the primary author and sponsor of the Americans with Disabilities Act. He is currently, among many other things, chairperson for the Partnership to Improve Patient Care, and in that capacity, he works to amplify the voice of the partnership's diverse members, including patients, people with disabilities, their families, caregivers, racial and ethnic communities, and the elderly, among many others. He is also currently the chair of the Disability Council for the Democratic National Committee and founder of the Coelho Center for Disability Law, Policy, and Innovation at Loyola Marymount University, and serves on the boards of directors for the American Association of People with Disabilities, and of course, the Epilepsy Foundation. Next, Ms. Sandy Fenugren. Sandy, I bring you warm greetings from everyone at the foundation. We miss you every day. Sandy Fenugren served the Epilepsy Foundation with the highest distinction for more than 18 years as both Vice President of Legal Government Affairs and Senior Legal Advisor. She developed the foundation's Legal Rights Information Clearinghouse, published several versions of its legal rights book, including a database of all federal, state laws affecting federal and state laws affecting people with epilepsy, and written and filed numerous amicus and important other briefs in courts promoting, of course, the interests of people with epilepsy, and was a catalyst for the ADA Amendments Act. Welcome home. And next, Ms. Arlene Marison. Arlene Marison is the Directing Attorney Emerita and of counsel for the Disability Rights Education and Defense Fund. She became the Directing Attorney of the Disability Rights Education and Defense Fund in 1981 and has devoted her career exclusively to disability rights practice. She is regarded as a key visionary and architect of the ADA. Scholar Leonard Davis noted Ms. Marison's contributions as, quote, the brains behind the Americans with Disabilities Act, close quote, and with that, I heartily agree. Ms. Marison has received countless accolades and awards for her work, notably the American Bar Association's Paul G. Hearn Award for Disability Rights, and that was awarded in 2016. And welcome, Arlene. And next, John Rodach, who was instrumental, of course, in the formulation of the Americans with Disabilities Act from his role and his view in the executive branch as chief of the Disability Rights section of the Department of Justice. He is chief author of both the Section 504 regulations under the Rehabilitation Act of 1973 and the department's ADA regulations. He served the government with the highest distinction for more than 42 years and now consults both domestically and internationally on implementation of the Convention, on implementation of the Convention on the Rights of Persons with Disabilities. And as I once described them to one of his grandchildren at one of many events where many people came to fet John, rightly so, and his granddaughter wanted to know how all these people knew her grandfather. And I said, well, you just have to think of your grandfather as sort of the Lady Gaga of disability rights lawyers. And she liked that. That made her, it helped her to understand that a little bit better. So welcome to all of you. We're going to divide our conversation into a few sections, starting with what it really takes to pass a major piece of sweeping civil rights legislation like the Americans with Disabilities Act. I think that history gets diminished and lost over time, and the enormous amount of work that went into that becomes some people marched and then there was a law, and of course we know that is only a fractional moment of that story. So I'd like to get that, kind of get that picture from all of you from each of these perspectives. So Tony, let me start with you if I can, and give us a sense of what it was like inside Congress while you were undertaking the leadership role in this.
Thank you, Allison, very much. I first sort of want to set the stage, and that is that it was really wonderful, the people that were behind it, the grassroots that created the opportunity for the bill to be passed. There was a grassroots effort all over the country. Justin Dart was very involved in setting that up, doing it. Joretta played a big role in all that, Arlene, of course. But it was a tremendous grassroots effort. I think the thing on the legislation, the positive thing that we had that I don't think a lot of people appreciate is that we had leadership on the Senate side and we had leadership on the House side. Leadership on the Senate side was Bob Dole as the Republican leader, Ted Kennedy as the conscience on the Democratic side. And basically having those two, they didn't have to fight the leadership in the Senate. That's really a key thing. On the House side, I was the Democratic whip. So I had the involvement in the leadership there. The majority leader at the time came to me at one point and said, your legislation is too broad. And what we need to do is to spend some time understanding it and convince the American people is the right thing. And I said, no. I said that we needed to move ahead. But I think that, I'm not applauding my role, I'm just saying that when you have leadership in both bodies, it's pretty hard to deny that. And so that starts it off. I put in the legislation. When I first put it in, there were 82 co-sponsors. And people came up to me on the House floor and said, I don't like the way my neighbor, my mother, my father, my brother, my sister, whatever is being treated with their disability, and I want to be on your bill. And so they became a co-sponsor. I guarantee you they hadn't even read my letter to them. They hadn't read any legislation. They just knew that people with disabilities were being mistreated and they wanted to do something about it. When I reintroduced it in the next Congress, we had 252 co-sponsors. That told you that when that word got around the House, what was happening and what was happening with the grassroots community, that people knew that this was something they should support. That didn't mean that it wasn't tough. What was happening in the Senate with the leadership there of Ted Kennedy, Tom Harkin, Orrin Hatch, Bob Dole, and so forth, they were able to get it through the Senate first and with very little struggle. And the House side, the leadership appointed it, the Speaker appointed it to 5 different committees. And I don't know how many subcommittees, I think it was 12, 15, I can't remember, but so many subcommittees. And the reason that they were doing what was to see if they could stop it, if they could slow it down. That was, we knew that. And so what we did is that Steny Hoyer was sort of the House manager, and Newt Gingrich appointed Steve Bartlett from Dallas as the Republican lead in the House. And so you had Steny and Steve working together on everything going through. That was critical to have both parties involved in leading the bill. And we started off with the most favorable subcommittee, and that was a subcommittee of the Labor Committee. And Major Owens was the chair of it from New York. And he basically shoved it through, made it happen on the subcommittee. And that started the ball rolling. And so we went through the different subcommittees, the different committees. We had some trouble with Dingell, and some of you may not know this, but the person that helped bring John Dingell around was Wonder Woman, Linda Carter, and her husband at a dinner party at her house. Linda turned to John and said, "John, I know you have some difficulties, but this is Tony, this is people with disabilities, you gotta be for it." That was an interesting exchange. But we went through Jack Brooks, one of the tougher guys in the House. He was reluctant, but it moved through the subcommittees, and then he became an advocate. And when they were voting on it on the House and in the Judiciary Committee, there was a roll call vote on the House floor, which meant that everybody got to get up and leave and then come back to vote. And Jack Brooks said, "Close the doors, nobody leaves until you vote." That was significant because it kept the momentum going. And so we did. And then it got to Public Works, and that was the real problem. And the problem there was Greyhound was spending money, spending effort, calling bus owners from all over the country to lobby their particular member on that committee to kill it. And they even brought in people from my district in Merced, California, a very close friend who owned a bus line and so forth to get me to say, "Well, this is unfair," and so forth. And when I explained to him why we were doing what we're doing, he said, "I'm with you," and turned down Greyhound. We also, an interesting thing is during that period when there was all this struggle going on and we were afraid we were going to lose it, Norm Mineta, I went to him, and Norm, when he wanted to get the Reparation Act passed for the Asian American community for what happened to them, I was a big supporter of that. The speaker at the time tried to withdraw it from the floor, saying we don't have the votes. Norm came to me and I said, "I'm the whip. I can count the votes. You have the votes. Don't let them take it off." We brought it up. It passed easily. So I went to Norm when we were having some trouble, and I said, "Norm, let me just tell you something. The ADA is my Reparations Act, and I need your help." Well, we passed it on a 21-20 vote, and it got through. And then when we went to the House floor, it passed overwhelmingly because on that second introduction, as I told you, it was 252 votes, but we co-sponsors, but we had others during this whole process and the grassroots community working it. Some of you remember the crawl up to Capitol steps. That was after the Senate action, before the House action, and that was a dynamite picture of those people from our community crawling up the steps, leaving their chairs behind and crawling up the steps. And so all that was going on. And then, I love Papa Bush. He, as some of you may not know, he had a daughter with a disability who died at a young age. And he and Barbara Bush were totally committed to what we were trying to do. We had people at the White House, particularly John Sununu as chief of staff, who said that he was going to recommend a veto. He didn't care what anybody else thought, but he thought it was too broad and so forth. When I called him, he confirmed that he was going to veto it, but then said, "I know what you're going to do and what others are going to do. You're going to call the president. He's going to want to sign it, and my position won't prevail, but I'm going to do it, and you'll have to do it to get the president to do it." Well, the president said, "Don't worry about it. I'm going to sign it, and so forth, and he did. So as we went through this legislation, the grassroots community was critical in creating the ambiance, but really the reality that this was something that really needed to be done. And having people in leadership positions in both houses made it bipartisan, and consequently, it never got into a partisan fight. It got into a situation, do people with disabilities suffer from discrimination? And practically everybody agreed. A very few, less than 10 on the Senate side, and I can't remember what the final vote was in the House, but it was less than 1/3 of the House. So that was sort of the process. It was exciting. It was so rewarding the day that it passed. The Speaker asked me to be on the House floor. I no longer was in Congress, asked me to be on the House floor. And I quite honestly have to say I was busting with pride for what the House was doing and what it meant to our community. Just want to add one thing. A lot of people think that this changed the laws in the United States. Yes, that's right. But it's also changed the laws and the attitudes internationally. Over 50 countries have an ADA law of some sort. Other countries are recognizing people with disabilities. So understand that what we did in the United States has had an impact worldwide for people with disabilities. And I want to say and thank the Epilepsy Foundation for their leadership, their involvement from the very beginning. When I introduced the bill, the Epilepsy Foundation is the one that really pushed and helped. Sandy was part of that. She was the lead in regards to the ADA Amendments Act, when the Supreme Court basically said that only those disabilities we can see, and John will give a more precise definition of that. But basically, the Supreme Court was saying that as one of the primary authors of the bill, that I didn't know what the heck I was doing because I excluded myself and every other person that had an intellectual disability or whatever. And so when that decision was made, I can remember very well, Sandy, we had a board meeting, the Epilepsy Foundation, and we agreed at that board meeting that we were going to fight, we were going to go after it and turn it around. And we did. The ADA Amendments Act was passed. And what it did, which is unusual, John can reference that, and Arlene as well. But what we did is we reversed a Supreme Court decision and said, you're wrong. It covers all disabilities. And so that's sort of the history. That's exciting for those of us in the epilepsy community because we were engaged the first time, we were engaged the second time. Sandy organized all the disability organizations, and they met regularly, invited me in and so forth, and we got it through. So that's the history of it. We in the epilepsy community should be very proud of our role.
Thank you. That was absolutely riveting description of the internal workings of that. So I was going to pause now for questions, but I think on the heels of that, I'm going to actually turn to John Rodach next and get his perspective of what this period of time was like from inside the executive branch.
Thank you. Thank you. Hello, everyone. And Tony, that was wonderful to listen to you go through all of that. Your memory is very well intact. That's great. I was at the Department of Justice, and so my perspective is from the executive branch. And I can start by telling you there is a lot of power to the promise made in a presidential campaign, because in the 1988 presidential campaign, I think Vice President Bush was trying to distinguish himself a little bit from the Reagan administration and establish himself as a caring conservative. And he endorsed the notion of having a law like the ADA, a law that would integrate people with disabilities, give them rights. Arlene is very good at talking about how they got to that point, and Arlene has a long role in how Vice President Bush became such an ardent supporter of disability rights. But that was powerful, and it was powerful because I was part of the negotiating team. And I can tell you the discomfort felt by most people in the administration when the negotiations were going on with Ted Kennedy and with Tom Harkin and we were on the side, their side, and everybody else was on the other side. And that left a whole administration and very many conservative people in the administration very much ill at ease. And so part of my job was negotiating that. And as we looked at one of the, and my boss was Dick Thornburgh, the Attorney General, who was a parent of a child with a disability, also had been a governor, and had the perspective of what this might mean for states. And but he was very committed, and the president came to him and said, "I want you to deliver a law." And he said, "Well, all right, those are my marching orders." He had an ally in the White House. Tony had mentioned John Sununu, who had been a governor of New Hampshire before he came to the White House. We had Boyden Gray, who was the president's legal counsel, who had a long-time relationship with Evan Kemp and other people and understood disability rights, but also was the president wanted this done, he was going to have it done. The same thing with Dick Thornburgh. And in the negotiations, part of what, there were a couple things that motivated the White House and got the conservative elements of the government in line, of the Republican Party. And one was relying on the history of 504. Throughout the 1980s in the Reagan administration, we had done over 100 504 federal regulations dealing with executive agencies of the federal government. And so, and they were done in the Reagan administration. They were done on the basis of negotiations between Joretta, the White House, and Justice Brad Reynolds. And so they were comfortable with those. And so the idea, if the ADA was going to have the definition of disability from 504, if it was going to say what discrimination is like Section 504, and if it was going to use the enforcement mechanisms of existing law, it made it seem less revolutionary. We were just giving to people with disabilities the same rights, through the same mechanisms that other people had in our country. And that notion of just bringing parity to people with disabilities under the federal civil rights laws was very powerful and kept people who were very conservative at bay. But even when they tried to raise up and stop things, which they did very often, the president was stalwart. He wanted this. He understood it. I'll give you one story before I stop. The way that in the executive branch the policy is given out is whoever is going to testify before Congress, and the Attorney General was going to testify before the Senate committee, and it was the administration position. And what happens is we drafted what he was going to say based on negotiations we've been having with the Senate, with members of the House, with the disability community, and within the administration. But then OMB circulates it to all the agencies. They have comments. And so the night before we're testifying, we're sitting in Dick Thornburgh's office, and OMB calls and starts saying, we want you to say this instead of that. And they started down a long list. And at one point, this is my view of profiles of courage story. At one point, Dick Thornburgh just drew a line in the sand and said, if you want someone to say those things, you are going to have to get somebody else, because I am not doing that. And if you want me to be out of the government, I will be out of the government. And he won the day, and he went forward the next day and testified that we were in favor of the law. There were some problems. We wanted to talk about, relief. We wanted to talk about relief for the business community and undue burdens and those issues. But it was a watershed moment for the executive branch to establish this is what we're going to do. And then they worked, and as a result of that, the deal eventually was worked out through the negotiations.
Thank you, John. Arlene?
Can I say something before we move on?
Absolutely, of course, please.
What I hope that everybody on this line realizes just how important a role Dick Thornburgh played. Now, he and Jenny had a son with severe disability. So they understood our community and were willing to stand up not only for their son, but for the whole community. So John is right. Dick Thornburgh showed courage and was willing to confront the conservatives in the administration. That's something we should always remember. And Jenny was very active with the religious community and getting the religious community engaged and supportive of us. So don't forget what John has said. Don't underestimate the role that Dick Thornburg played.
Thanks.
Arlene, what does it mean to be a lawyer involved in this kind of a massive effort to pass a sweeping civil rights bill? I know that this has been your life's work, and you worked on this for years with many others, including Liz Savage and Pat Wright and people I'm sure that I will be forgetting to name. But draw a picture for us of what your role was, what the role of lawyers is in this process.
Well, thank you, first of all, for inviting me to this. And I have a 5 hours, 10 hours, 20 days worth of stuff to say, of course, but so I'm going to highlight a couple areas. So first of all, I want to talk about the role of Joretta, Disability Rights Education Defense Fund. At the time, I was directing attorney of Disability Rights Education Defense Fund, and I worked very closely with Pat Wright, who is usually called the general, in that she had her hands in, I was going to say in every pie, but kind of over every pie. And so she is not a lawyer, although they say that she graduated from the George Bush School of Law. George Bush said that. But I worked very, very closely with her and provided the legal analysis, which I'm going to go back to in a minute. And then I want to talk about Mary Lou Breslin for a minute, because this relates to what Tony was saying about how there wouldn't be this law without people with disabilities across the country. And as John said, the predecessor to the ADA was Section 504 of the Rehabilitation Act. And as many of the people on the call know, the act was passed in '73, and it took 4 years of very intense advocacy by people with disabilities across the country to get the regulations out. And the regulations form the basis of the ADA. And in between that, after the regulations came out in '77, Mary Lou Breslin headed up a national training, gigantic effort to go around the country, every city, every town, Indian reservations, everywhere, to train disabled people in these newly developed rights under Section 504. And she went around and said, stop begging and stop apologizing for what you need. You got to develop a rights-bearing attitude. And the people in the audience included people who had never left their institution, who had never left their homes. So this made a huge impact on these thousands of people that were trained. And this was under the Carter administration, where there was money for those kinds of trainings. The federal government organized the disability community across the country. And that formed the basis of a very active constituency, and a constituency that held 504 rights in their hearts. That it wasn't something that when Reagan came in and said, oh, we're going to take away those rights, that they sat back idly and let happen. And in fact, it was the consistencies across the country that defeated all attempts by the Bush administration to deregulate 504. And why I go, and Mary Lou Breslin headed that effort up. And why I go back to that is I have a very strong belief that we wouldn't have an ADA unless we had already established the credibility to show that there was a community out there, that the community was smart, active, and knew what they were doing. So that's just, in terms of Joretta. And then, of course, there was Marilyn Golden. Now going back to the 1988, 89, 90, Liz Savage. She worked for the Epilepsy Foundation, and we're forever grateful that the Epilepsy Foundation allowed her to do that work. We kind of considered her like part of the Joretta team. And again, an unsung hero, because Lizzie was in charge of the organizing when the bill was going through the legislatures. And as Tony mentioned, I mean, it was already hard enough in the Senate. But it was quick. In the House, Lizzie was organizing all the subcommittees, all the committees, all the subcommittees, and making sure that people came in from all over the country. Oh, there's a senator from Idaho, and that senator has all kinds of issues. So we need someone from Idaho that is the most appropriate to address those issues. I mean, it was a huge undertaking. Maryland was a part of that also, as well as Maryland Golden, as well as being very, very key in the transportation aspects of the ADA. So Joretta and Lizzie from the Epilepsy Foundation were kind of like our team. And then there was also the whole disability rights community, and of course, the input of that community all along the way and being kept in the loop all along the way. And then there were lawyers who were very involved. And as a generalist, I worked very closely with Kai Feldblum. And then there were people who were very specific to various areas, like Jim Weissman, who did transportation, and Cy DeBow, who did things having to do with communication barriers, and Karen Strauss. There were very specific people on very specific issues that they had worked in for a long time. So it really was an organization that was extremely well coordinated because of the leadership of Pat Wright, because of what Lizzie was doing to keep her tabs on everything that was going on. And as lawyers, and Allison, I'm really glad you asked the question, because I think that people don't know, and I certainly wouldn't have known, what it takes to pass a law. And so we, at the very beginning of the process, we were taking a law that was tremendously expansive, that had been written by the National Council on Disability, a wonderful, very essential part of this whole process. We were taking it, and as John said, kind of, how do we mold it to be a law that will pass? And a key element in that was to whatever extent we could, use 504. And the regulations under 504, because by the time that we were talking about the ADA, 504 was 17 years old. And although it only applied to recipients of federal financial assistance, it was generally the same kind of provisions, but applied to the private sector. So we were able to say, the sky is not falling, which is what we heard constantly. It wasn't all super cozy in terms of some of the business groups and the Restaurants Association, et cetera. I mean, there was a lot to fight for and to fight against. And so we started with that process of drafting, and there were a couple key principles. And one of them was, let's make it as close to 504 as we can. As we found out, of course, later, and Sandy will talk about, the 504 definition of disability, which had basically never been an issue in all of 504 litigation, became a huge issue in the ADA when we adopted it, because suddenly all the corporate lawyers and, they got their heads together and they were like, we got to dismiss these claims. And Sandy will talk about that. So, it's a matter of molding the provisions and then explaining those provisions. And one of the things that I like to say, and that I found amazing, is that members of Congress, both on the Senate and the House side, had zillions of questions. And they had questions about, how will this affect? Well, they got questions from their constituents, so they were passing them along as well. And they were questions like, does this mean we're not going to have bar stools anymore? That's just key. And everything from that to, well, can we no longer do psychological exams for police departments? At which point, this was in the House side, and Mr. Hoyer was like, okay, we need to know tomorrow, what are all the police departments in the country doing about this? And so we're calling all these people around the country for police contacts. So it was practical in the sense of answering practical questions, coming up with answers that were based on some kind of precedent, or that, made people understand and appreciate that the whole world wasn't changing, although it was changing in very fundamental ways. Then there was legal analysis. So everyone everyone knows that our rights are based on the rights of racial minorities, ethnic minorities, and women in this country. And so we were building upon that, building upon those movements, building upon the words in those statutes and those regulations. But it was very important to explain why there had to be differences. And the basic difference was that same treatment wasn't going to work, that we had to have accommodations and barrier removal. And so non-discrimination kind of changed from treat everyone the same to give everyone equal opportunity. And that's the linchpin of the ADA, equal opportunity. What does it take for someone to have an equal opportunity to ride the city buses? It takes lifts. What does it take for someone with a learning disability to have equal opportunity on a test? It takes extended time. So there was a lot of legal analysis that was involved as well. There were prepping witnesses for hearings and, creating like the hearings are, I teach disability rights law and have for a long time. And I always show the hearings and ask the question, well, why is that witness there? Why is that witness there? And they're very strategic answers to those questions. And they, a lot of times had to do with where they were from, because the member from that state was having the problems, et cetera, et cetera. So that I also served as a witness and several times. And, it involved putting forth a legal analysis, but also the moral imperative of this law. It involved, really working closely with staff and members of Congress about explaining the law and then documenting those explanations in committee reports. And many things in the committee reports have been extremely important in future litigation, which I've had the privilege to do for all the time since the ADA has used those words to make the world more open to people with disabilities. So, and I wanted to talk about a couple times where it wasn't like a big kumbaya in terms of the bill was very bipartisan, and it really is a hallmark of bipartisanship. It's a hallmark of what people can do when they're used to working together. It's a hallmark of having legislators who are masterminds in negotiation, et cetera. But the one place where it really kind of broke down bipartisanship is when it came to things like civil rights remedies. To the extent that we were building on civil rights laws, and it coincided with Ted Kenny's big initiative to add damages and to get more relief under Title VII. And so at that point, there was a divide between Republicans and Democrats because it had to do with provisions that would end up affecting these other civil rights laws as well. And there was some friction, but we were able to always pull it together. And the thing I'm most proud of in terms of any kind of friction within at least the disability community is at the very end of the House process. And that it means, like, again, being a lawyer in this process means that, you're ready at any moment. And things come up on the House. They come up on the House floor. You're never done until you're done. And so, many of you know about the AIDS amendment or the food handlers amendment. And there was a way to kind of have an inroad in weakening the protections for people with AIDS, which are very, very critical to our coalition, extremely critical to our coalition and what we believed in. And so they said, okay, fine, but food handlers with AIDS won't be covered, won't have any protection. And the community that had fought so hard for so many years, going back decades, for basic things like transportation access, and who had won that, were confronted with, are you willing to give it all up so that food handlers with AIDS can be covered? And the thing I am most proud about the coalition of groups with disabilities is that people stuck together. And why? Because the amendment challenged the very most fundamental part of the ADA, which is you don't make arbitrary decisions based on prejudice. You make them based on science. And one of the, I haven't been too happy with him since, but one of the heroes of that story is Senator Hatch. And why? Because he had such a close relationship with Senator Kennedy. They were able to work it out. It was just absolutely, there were no moments that you couldn't be called upon to work. I was in DC for all the critical moments and a lot of the negotiations, and as John said, the negotiation with the White House and with members of Congress and et cetera. But I was also in Berkeley, where I live, and all that meant was that we could keep the machine going 24 hours a day because of the 3-hour difference. So it was an amazingly thrilling time, but it was what I tell my law students, what I tell people is that it is work, 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 responsiveness, gaining trust, and, you know, not thinking that you are only doing one thing. You're doing everything as the lawyer, and you're there to explain legal precedents, but you're also there to find witnesses, and you're also there to write language, and you're also there to help with committee reports. And so it's a soup to nuts job, and couldn't be prouder and happier that I got to be a part of it.
Thank you so much. That was a fantastic description. And I know we have a multi-generational audience joining us, and I too teach a class of disability law at Georgetown, and I start with a lot of the history around 504. And for those of you who don't know, a really important piece of disability rights history is that it is still true today that the longest siege of a federal building occurred in California when disability rights advocates took over the HHS offices and agreed that they would not leave until the administration pushed out the 504 regulations so that the law, Section 504, could be enforced. So you undertake, we have a vivid description of what it takes to pass this law. It then does get passed. Many people who've been waiting really their lifetimes to have their civil rights enforced come forward. They start filing complaints, which takes a lot of courage for them to agree and give a nod to the people who are willing to do that and be involved in a sometimes grueling process of litigation to enforce those rights. And then federal judges start making decisions. And I think one of the things that happened very early was we began to see, as a couple of you have already mentioned, cracks in the definition. Courts started to narrow the definition in ways that it was pretty clear to all of us Congress did not intend. And so with that, I'm gonna go to Sandy, if I can, and have you talk about your experiences around that and talk about the Amendments Act.
Great. Thank you, everybody. Can you hear me?
Yes.
Great. I just want to back up just a little bit and first thank you, Arlene, in particular for that description of what happened during the ADA passage. I was actually working in, had been at the foundation far longer than 18 years and had been working in legal advocacy and was not involved with the government relations activities, but I saw Lizzie Savage and Julie Ward and Liz Borda and Richard Nugent, who were really leading that effort, working all the time on the ADA. We were benefiting at the Epilepsy Foundation from the passage of the Rehab Act of 1973 and then the amendments. And I mean, for the Epilepsy Foundation, which had really not been involved with legal advocacy per se in its history, the 1970s were the passage of the Education for All Handicapped Children Act, the Rehab Act, the DD, Children on Disabilities Bill of Rights Act. They developed their first legal advocacy committee and said, we are going to get involved with all of these issues because people with epilepsy are in institutions, they cannot get jobs, they cannot thrive. And so this was going to be a major push for the foundation. So I was doing cases and answering questions and getting people to lawyers in those cases and really relying upon the Rehab Act very successfully to open doors that had never been opened before. So it was a surprise when we started to see the limitations with the ADA, except that I also had some role as legal counsel as well for the foundation and was attending some meetings with business communities. And I remember coming back from a meeting in the early 90s and saying to others, this is going to be really bad. because there was such a concerted effort to limit the ADA going on by law firms, big business, that we were just going to be fighting cases constantly over things that we had never intended that would be an issue. And in fact, that's what came to pass. You know, the law passed in 1990, and incredibly good things happened. I mean, law enforcement, a big issue today. We were able to give major funding to law enforcement around the country under the ADA so that they could do training and education for law enforcement across the country on recognition and management of people with who had hearing, who were hard of hearing, people who had epilepsy, other impairments. So those good things were all very, very useful. The Supreme Court had a series of opinions in 1999, a trilogy of opinions, and was the United Airlines, the Sutton case, United Airlines case, a UPS case, Murphy versus UPS, and then a case at Albertsons, a big grocery store versus Kirkenberg, in which they basically said, in all of those cases, in a variety of different ways, that you look at a person with a disability in identifying who had a disability, you look at them in their state after they have been taken their medicine or for epilepsy, or taken their medicine for high blood pressure, or after their brain has overcome their disability so that they could function. So they said, and what many people thought was a reasonable idea, a person who wears glasses or has a vision impairment is not covered by the ADA. So even though United Airlines was not going to hire pilots who had corrected vision, because their rules were you had to have uncorrected, a certain level of vision, that those people could not take advantage of the ADA. If you had high blood pressure that was corrected with medication, you would not be covered by the ADA because there was a DOT rule that you couldn't have high blood pressure to be a commercial truck driver. If you had monocular vision, you could see only one eye, you've been a successful truck driver for a company, but you were able to function well, but you had effectively monocular vision, because your brain had adjusted and adapted and allowed you to drive safely, did not give you coverage under the ADA because you no longer have a disability. So even though the company followed DOT rules that said that you have to have 20/40 vision at least in both eyes, and therefore you couldn't be a truck driver. So they followed that rule even though there was no legal protection for somebody who was fired because they had that condition. We realized at the Epilepsy Foundation and the field of epilepsy that this was going to be a disaster for us, because obviously not only epilepsy is an episodic condition. You take medication, and for the majority of people with epilepsy, it controls their seizures well. But nonetheless, there are many, many employers who wouldn't hire somebody out of the fear of somebody having a seizure. And it didn't take but 3 months after those decisions, I think it was, when the first case came down. A man was fired for having a seizure in Texas on the job, and he went to court to sue, and they said he does not have a disability under the ADA because when he, most of the time, it was not because he takes medicine, it was that most of the time he's fine. The seizure only lasts for less than a minute. And maybe there's a brief period afterwards where he's confused, but that's only a few minutes. That does not amount to a disability under the ADA. So he was not a person with a disability. So our response, of course, was to go to the EEOC to talk to them about what we might possibly do to counter this, to put out guidance, because we thought this is going to happen. It's going to get worse, that more and more people aren't going to get covered under the ADA. We went to our fellow disability rights organizations. We went to Joretta, was involved. The National Disability Rights Network was involved. Diabetes Association. I mean, everybody who was working in the rights, the CCD Rights Task Force, that's the Consortium of Citizens with Disabilities as a rights task force. And we talked about this issue. And everybody recognized the problem, but it was very narrow and limited. And we are in a time in which trying to do legislative corrections quickly seemed to not be a possibility. Over the course of the next several years, then another case came out, Toyota versus Williams, in which they the Supreme Court further limited the definition of disability by saying that you had to interpret whether somebody was substantially limited in major life activities. You had to interpret that very strictly, and it was a heavy burden to show that. And so a woman with carpal tunnel syndrome, well, the court had not actually addressed that issue, but the implication was that a woman with carpal tunnel syndrome would not have a disability under the ADA and wouldn't be protected. So the reasoning of the Supreme Court in those decisions began to affect many, many conditions that had all been covered under the Rehab Act. And you could go through the list of who the EOC regs said that people who should be covered, or DOJ said regs, people would likely be covered, and they were all not getting coverage under the ADA. And it was really becoming a crisis point. I mean, we had people who were missing limbs who weren't covered, people who had severe intellectual delay who weren't being covered. So the community of people with disabilities adversely affected by these decisions grew larger and larger. And I would say, and there was a lot of work going on again, and this is cross political parties. NCD, the National Council on Disabilities, had been meeting regularly with all of us, with John Rodach and people in DOJ to look at how we could address all of the problems with Supreme Court decisions that had narrowed the scope of the ADA. And they came up with a report called I think it was called Writing the ADA or something like that in 2004. And that report was a really critical, they had, in terms of gathering consistent information from around the country and then coming up with a proposal that people could basically give us they could give people a guideline on what areas needed to be addressed. And I want to be clear, the definition wasn't, a major issue, but it was not the only issue. There are still other issues that really, the Supreme Court has created problems for us that could be addressed. Nonetheless, I would say that the definition in general was the one area where if you can't even get in under the law, it doesn't matter what the rest of it's about, whether you've gotten a reasonable accommodation, whether you get attorney's fees, how do they determine whether you're a direct threat? All of that is limited if you're not covered by the law. And the tide turned, I would say politically, when we moved to a Democratic majority in the Congress, in both sides of the Congress in 2007. That doesn't mean that there wasn't activity going on before then, but I think that makes a difference. I mean, there had been, it was Republican House, Senate, and administration for the first few years of that time period. And one of our big problems is that we didn't, in terms of legislative advocacies, we did not want this to be a partisan fix. This had to be bipartisan, number one, in order to get it to work, but number two, because the ADA was bipartisan. Disabilities affect people across the political spectrum, and we needed the support from all sides. And we had a little opening that happened, I think, and I do want to do a shout out to Jim Sensenbrenner, Congressman Jim Sensenbrenner, who at the end of 2006, he was still the chair of the Judiciary Committee. And we had been trying to find Republican leaders who would support a legislative fix on the definition. So we had been meeting with many people, but we met with Sensenbrenner, and he did a hearing on the topic. And we had been hoping at the end of the hearing that he would come out with a report that would describe the problem for Congress, and with his leadership, we could move forward with something in the next session of Congress. And I just want to say, Jim's wife, Cheryl Sensenbrenner, had a disability. She also had a sister with a disability. And unfortunately, we have lost Cheryl. She recently died. She was an incredible force of energy and personality. And she clearly influenced her husband as well, and everybody whom she met with. And I want to tell you a short story about her moving forward on this, but I did want to recognize that. But anyway, at the end of the 2006 Congress and Jim's term, he was going to be term limited as chair, we get a phone call from his staff person, his legislative staff person, and says, Jim wants to drop a bill on this. And he just wants to address the definition, and that's it. And so we scrambled. I mean, this is 12 hours turnaround time. And you say, okay, take the definition basically from the NCD bill, add a broad construction to it, and go with something that we could live with. And he did. He went with that, and he introduced it at the end of that Congress. And then that was it. The world didn't come to an end. And then the parties changed, of course, by November. There was a change of the party, so there was new leadership, and then there began to be hearings held in the Senate held a hearing, Health Committee held a hearing, and of course, Senator Hatch, of course, had always been a leader on this, and he held a hearing on the issues. And it was noteworthy that, to me, in the Senate hearing, is that a lawyer for the Senate, for the Chamber of Commerce, after we had presented all the testimony, a lawyer for the chamber, Mike Eastman, came up to me at the end, and he said, I think we can work together. And to me, that was a very clear signal that he recognized that there was a problem with the definition. I think they had been so successful with limiting the scope, it went far beyond what they thought they could get away with. And, I think they recognized that it had been too narrow and it was violating the spirit of the law. At any rate, there were signals there. And we continued the usual work that Arlene has described then. We had multiple committees, a legislative drafting committee. We had a grassroots committee that was working with CCD, with people all over the country. We had a lobbying committee that was working with bringing our message to different people of Congress. We also had the good fortune to have Georgetown University's legislative drafting clinic, their federal legislation clinic, take us on as a client. And at that point, Hy Feldblum was leading it, and Heather Sawyer came and worked with us, which was also a critical thing, to have all of that legal energy of all of those students and those lawyers helping us support. Every time there was a legal question on an issue, somebody could do the research and answer it and get it back to them. So hugely important. The other thing is, every piece matters, right? Everything's important. It's the contact with people in the field. It's having Republicans and Democrats in leadership who will support you. It's having the grassroots that's out there, and then having them all work together in a coordinated fashion. That's really, it's a structure for how it could happen. Again, another signal that we had sort of a will that was going to work, a will in Congress that this would work, was we brought in a man named Kerry McClure, who had a case against, I think it was General Motors. He was an electrician who had 20-year history of being an electrician successfully, got a new job working for GM, went to get the job, went to go and moved across the country to Texas for the job. Moved from Georgia to Texas. And when he got on the job, there was a medical exam. And the medical examiner said, how can you do your job? Because he has a form of muscular dystrophy where he cannot lift his arms over his shoulders. How can you be an electrician? He says, well, I use a ladder, I use a lift so that I can lie on my back and put my hands over my head. And he flunked the medical exam. So they withdrew his job offer. He had all of those losses. He went to court under the ADA, and he lost, of course, because he was able to function in all of his activities of daily living successfully with minor adjustments. And so he did not have a disability under the ADA. I'll tell you, that hearing room, this was in the Education and Labor committee room, and
So
it,
I had to
George,
share. I want to thank you for that particular story because I think that is absolutely one of the most important cases that got people to understand why it was necessary to fix the definition. I have now the sort of unhappy task of having to draw us to a close. I wish this could go on for many, many more hours. I want to thank each and every one of you, not just for today, but for the the life choices that you have made to be in the service of others for a cause greater than yourselves. Uh, Certainly, people with disabilities have greatly benefited from that, but the whole world has benefited from that. I have benefited from that as well. Um, I describe the job of being a civil rights lawyer as getting together with your friends and setting about mending the broken world. And I want to thank each and every one of you for all that you have done to mend the broken world. For our audience, the Epilepsy thank you for tuning in. The Epilepsy Foundation is going to continue our conversation about the ADA. We'll be doing a series of webinars focusing on the employment of people with disabilities, and you may see some of these, if we're lucky, some of these same people on those webinars. And for now, I want to thank you for joining us. And
Allison, let me make
yes,
one
please.
comment. Allison, let me make one comment. I just want
Absolutely, of course.
everybody in the audience to know just how important the Epilepsy Foundation was on the ADA and on the ADA Amendments Act. You should be very, very, very proud of what the Epilepsy Foundation did. That's what it's all about. Congratulations to all of you, particularly congratulations to the Epilepsy Foundation, Liz Savage and Sandy Fenugren. But we made a difference. Feel proud of it. Keep your work up and your advocacy. It's very important.
Yes, sir. Thank you to everyone. Good
Thank
afternoon.
you.
thank you.
Okay, I got it, Britt. Thank you.